Good morning, good afternoon and good night learners. Let's learn the law, civil justice and tort law. Unit 3 Legal Reasoning. This unit introduces you to what happens when a legal dispute goes through the courts, considering how the courts take the facts relating to legal disputes, analyze them, assessing what is relevant or not, and make legal decisions based upon them. It also considers what happens when decisions are made and the process through which judges record their decisions so that future courts can follow them, if it is appropriate to do so. Fact-finding. The first step in resolving a legal dispute is finding the facts. Correct fact-finding is vital to a just outcome. For example, if a court wrongly found that parents had mistreated their child when they had not, that child could be taken away, with terrible consequences. The process of working out from the evidence where the truth lies is generally known as fact-finding. There are some instances when the opposing parties are agreed on the facts, but these are quite rare. Generally one side makes claims that the other side disagrees with, so the court has first to decide where it thinks the truth lies. A legal dispute often comes to court some time after the dispute arises, and the fact finder, also known as a tribunal of fact, has no previous information about the dispute, so they have to try to work out what happened from the evidence that is presented. In civil cases, the tribunal of fact is normally a judge or a panel of judges, but sometimes it can be a jury. In most civil proceedings, fact-finding is done by the trial judge or judges. This would generally be trial judges sitting in the county court or high court, though fact-finding can also be done by a jury in the handful of exceptional circumstances where a civil jury is used. The majority of fact-finding also takes place during the first instance stage, that is, before any appeal. If a case is appealed, the appeal court rarely hears evidence, so the appeal court will tend to rely on the facts that were found by the first instance fact finder at the very start of the dispute. As we shall also see towards the end of the unit, fact finding may be a point at which bias can creep into the legal process. Everyday fact finding. Fact finding is something that people do day in, day out with such ease that they rarely think about it. Fact finding is a type of inference. Inference is where we draw conclusions by combining evidence that we hear or see with existing knowledge. For example, when a person's mobile phone alarm goes off, evidence, and even before they open their eyes, they infer that it is 7 a.m. Fact, on the basis that that is the time the alarm always goes off. And if there is a knock at the door, evidence, they infer before opening the door that it is a delivery, fact, because they are expecting a parcel and not a visitor. In the next section, you will see how legal fact-finding is similar to everyday fact-finding. Legal fact-finding. Fact-finding in a legal case is just like common-sense fact-finding in everyday life. The fact-finder has to use the evidence that is available at the trial to infer what they think happened in the past. For example, the court might use skid marks on the road to infer how fast a vehicle was traveling before it was involved in an accident, or medical evidence to infer how likely it was that the claimant's disease was caused by exposure to toxic particles in the workplace, or chemical analysis to infer how likely it was that a particular company polluted a river. However, when making findings of fact, the fact finder also has to follow legal rules contained in common law cases and parliamentary statutes. For example, in the previous section on everyday fact finding, we noted how fact finding is never certain, only probable, and a fact may be found with varying degrees of probability ranging from 0%, impossible, to 100%, dead certain. In everyday life, it is up to us what degree of likelihood we want to rely upon in making decisions. But in law there are legal rules that impose very strict requirements on what degree of probability is acceptable. The standard of proof. The law generally treats fact-finding as a simple yes or no question, so we have to translate the grayscale of probabilities into a straight black and white answer. This is called the standard of proof, and in civil law context this standard is, on the balance of probabilities. The balance of probabilities means more likely than not. Therefore, anything with a probability of 50% or less is taken not to have happened, and anything with a probability of 51% or more is taken to have happened. The burden of proof. The standard of proof still does not tell us which way round to apply it. Does the claimant need to show that something is 51% likely, or does the defendant need to show it is 51% likely? So we also need the burden of proof. The law is that the burden of proof is on the side alleging that a particular fact is true. So a claimant who says that a defendant polluted a river will need to show that it was at least 51% likely that the defendant did so. And if the defendant says that the pollution was instead caused by a factory further up the river, the defendant will need to show this with 51% probability. There are other legal rules that must be followed when fact-finding. Sometimes these rules have a drastic effect on the fact-finding process. For example, public interest immunity is a process recognized by common law rules where the government can apply to a court to exclude evidence that would otherwise be used because the government believes it would harm the public interest. For example, the evidence might put an informer's life at risk if disclosed, or it might harm national security. Just before World War II, an experimental submarine sank while being tested, killing 99 sailors. When a claim was brought against the shipbuilders, the House of Lords upheld a certificate from the government that it would damage national security if the designs for the submarine were disclosed. This meant that the plans could not be used as evidence. Duncan v. Kamel Laird and Company Limited. Public interest immunity is controversial because it can affect the fairness of the trial. Nonetheless, the Tribunal of Fact is obliged to follow these laws because if it does not, its decision will be overturned on appeal. Material facts. Not all facts are important for legal reasoning. The facts that are important are called material facts. Material just means relevant, and are facts that make a difference to the decision or outcome. For example, in a negligence claim arising out of a road traffic accident, it would be a material fact whether or not one of the drivers was using their mobile telephone immediately prior to the accident. If he was using his telephone, then the judge may decide that he was negligent, whereas if he was not using his telephone, then the judge may not decide he was negligent. Then there are other facts that are just background and would make no difference to the outcome. For example, the color of the driver's shirt would be unlikely to be a material fact. When a case comes to court, the parties may agree on some facts, but disagree on others. The disputed facts are called issues of fact, whereas the undisputed facts are called agreed facts. The court has to determine the issues of fact. This unit focuses mainly on issues of fact. This unit will also assume that the law is certain and agreed on by the parties. However, there are times when the parties disagree what the law is. A disagreement about the law is called an issue of law. The next unit, Unit 4, will look at issues of law in more detail. In this section you learnt about the first stage of adjudication, fact-finding. In the next section, you will find out about the second stage, decision-making. The second important part of adjudication is decision-making. So in everyday life I can pretty much do what I want. I'm standing in this wide open space, so I could go this way, I could go this way, I could stay where I am, I could sit down on the ground, I could take my hat off and throw it at that annoying crow, or I could take my clothes off. Probably not advisable in this cold. I have total freedom to do whatever I want. Legal decisions are similar to these day-to-day decisions, but with important differences. Often, they deal with fundamental issues that can be life-altering, but they can also be quite trivial. Legal decisions are like everyday decisions, but rules prevent the types of choices which otherwise you might make. For example, not every member of the public can walk into Lincoln's Inn, unless you're a member of the inn. In law, whether a decision is sustainable, depends on whether it's lawful or unlawful. The most important difference is that black-letter law in common law judgments and parliamentary statutes limits the decisions that an adjudicator can make. If an adjudicator doesn't follow the legal rules, their decision is unsustainable, meaning that it can be overturned. Now you have studied both fact-finding and decision-making. In the next section, you will study the third important stage of adjudication, giving reasons. The third important aspect of adjudication is giving reasons. The first stage, fact-finding, is traveling from evidence to facts. The second stage is traveling from facts to a conclusion. But if all you're presented with is the conclusion, you have no idea how the judge got there. They could have got there by a lawful route or an unlawful route. Whereas if they give reasons, you can tell if the route which they traveled was lawful or unlawful. And if it was unlawful, then you can appeal. First instance courts responsible for both fact-finding and decision-making will generally explain both, but appeal courts will generally only give reasons for decision-making, as that is their primary focus. Reasons are also important, firstly because they're a way by which the common law develops, step by step. And secondly, they're a fundamental part of the common law and human right to a fair trial. Even experienced, professional judges sometimes struggle to explain the reasons for their thinking. It can happen that two judges reach the same conclusions, but for very different reasons. Anatomy of a judgment. Anatomy is the structure of where organs are located in the body. The reasons set out in legal judgments also have important parts, but unfortunately for lawyers, judges do not always put those parts in the same place, though some courts are more consistent than others. This means that to understand legal judgments it is more helpful to recognize the parts than where they are located in the judgment. To begin with, it can be difficult to distinguish, say, evidence from a fact, or an issue from a rule. Bias in judicial decision-making. Up until this point, this unit has been primarily practical, focusing on the nitty-gritty of doctrinal law, how judges make decisions, and how understanding these provides tools to answer practical problem questions that are commonly asked of law students to help them develop their legal skills and knowledge. But now you have a working understanding, we are now in a position to look at a deeper socio-legal issues of bias in legal reasoning. These issues are ones that may deserve wider political discussion that would be more appropriate in an essay. At one extreme, some doctrinal lawyers believe that the cases and statutes that form part of the black-letter law always provide the answer, and that judges have very little discretion as to how they decide a case. This view is sometimes called formalism, and is associated with academic lawyers such as Christopher Columbus Langdell, dean of the Harvard Law School in the late 19th century. If the law does not leave a judge any discretion, then it seems there is no scope for bias to creep in. The law is the law and it does not matter who the judges are. Holland and Webb, 2019, p. 129. Formalism is sometimes called the official theory of judicial behavior, because it gives the impression that adjudication is not political. Posner, 2008, p. 41. This can be attractive to a judge who wants to avoid controversy. But in the 20th century, a group of American lawyers, many of whom were also practicing lawyers, began to question the neutrality of law. At the other extreme, Felix Cohen called doctrinal law transcendental nonsense, because he thought it was entirely useless for predicting how a judge would behave. Cohen, 1935. They were called legal realists because they sought a more realistic picture of law. If judges do have freedom to decide cases, it may be important who the judges are. Empirical evidence. Arguments have raged between formalists and realists about how much freedom judges have, but empirical evidence suggests that the realists were at least partially right. Psychologists have recognized a phenomenon called motivated reasoning, which is where decision-makers are influenced to choose the outcome they prefer. Kunder, 1990. For example, Balketis and Dunning, 2006, asked participants to decide whether an ambiguous character, I3, was a number 13 or a letter B. Depending on which they chose, their task was to drink some orange juice, or a vile health drink. Perhaps unsurprisingly, participants preferred whichever interpretation let them avoid the vile drink. Experiments in a legal context have found that lawyers are also influenced by their outlook. For example, Redding and Repicci, 1999, found that U.S. judges and law students' decisions on whether to admit empirical research about the death penalty as evidence in a trial were influenced by whether or not they supported or objected to the death penalty. At the appellate level, there is also considerable evidence that appellate judges' decisions are influenced by their attitudes. While we know that motivated reasoning happens in a legal context, researchers do not have a clear picture of when it occurs. One aspect that seems to make a difference is whether the bias can be hidden. Kunder, 1990. Note that in the exercises earlier in this unit, some of the fact-finding and decision-making were easy, where almost all judges would have come to the same conclusion. If a judge had come to a different conclusion, it might have looked a bit suspicious. Other cases were hard, where reasonable judges might have decided either way. These are the cases where the effect of bias is more difficult to spot. Overall, the potential for bias provides an argument in favor of a judiciary that reflects the community. Feminist Legal Judgments Project. In England and Wales, in common with most other jurisdictions, the overwhelming majority of judges have historically been, and continue to be, male. Ministry of Justice, 2020. To highlight the effect this has had on the law, scholars have rewritten many key common law judgments from a feminist perspective. E.g. Hunter, McGlynn and Rackley, 2010. These scholars seek to demonstrate that judges that believe in equality between women and men would have decided the cases differently, and would have given different reasons for their decisions. You should now be able to explain and distinguish fact-finding and decision-making. Explain how legal rules influence fact-finding and decision-making. Explain the importance of reasons in common law judgments. Identify the key parts of legal advice and common law judgments. Discuss the issue of bias in the common law. Please like, comment and subscribe.